for joining us, everybody. We've actually got over 250 people registered for the session now. I'm sure not everyone will show up. That's the most we've ever had for special interest groups. So I'm absolutely delighted. A couple of sort of housekeeping things. First of all, if you've got any questions, please just put it in the comments and we will answer it at the end of the session. We're hoping that Ali will cover most of the salient points and major points. So what we don't want to do is interrupt that flow, etc. So that'll take about 25, 30 minutes, etc. We have also got some pre-questions that people sent in this beforehand, so we'll also be covering off those as well. And what I would say is that at the end of the session, we will be having the opportunity as well that if there's any people who've got any questions, etc., they can share us with those with the eAA or Ali, and we'll get those answered as well. Now comes a disclaimer. Now, obviously, Ali is a lawyer and he's an expert in this field. However, we have to say that this is not legal advice. So if you've got specific examples, specific use cases, then you do need to consult a professional. And I will also add that while I am the CEO of the assessment associations, I might be quite slightly adversarial in some of my comments because to get the discussion going. So again, that's not necessarily the opinion of the eAA or anyone. I'm not a professional anyway, not in terms of the AI Act. The last thing to say as well, if you do go to artificialintelligenceact.eu. The act is there. They've actually got some useful tools in terms of the summary, which is really great, actually, if you don't have to work through the hundreds of pages. And also there is a little sort of a tool that will allow you to assess if you are liable, if you're impacted by the AI Act. I think it's one of those, a bit like the UK government have, is the answer is yes, you will be, but whether that's accurate or not, I don't know. So anyway, I will now pass you over to Ali, who will be able to tell you about himself and then start the presentation. Thank you very much, Ali.
Oh, cheers, Pat. Hi, so I'm Ali and I'm a partner in the data privacy and cyber and AI teams here at Lewis Silkin. About us, we have offices in various jurisdictions and we're known for kind of protecting ideas, people and possibilities there. So when it comes to AI, what we're going to be looking at today in the context of education, I've kind of put an agenda together there. We're going to look at how AI systems are being used in education settings, the sorts of instances where things can go wrong, do an intro to the AI Act and who it applies to. We'll then have a look and try and understand why AI systems in the context of education is a particular focus of the AI Act. We'll look at risk classifications of systems used in education. We'll have a look at the different obligations and also kind of consider a little bit about what's happening in the UK and also what we need to do next. Now, in terms of how these systems are used, you're probably all closer to it than I am really, but I found this document from the European Commission quite helpful because it provided a good summary of how these different systems are being used by educators and learners to support the teaching, learning and assessment process. So there are many different types of use case, and you know the one that we're going to be focusing on, I guess, largely today is kind of the teacher support, the summative writing assessment, essay scoring, so using AI for evaluating and grading work. But there are many different types of use case there. And things can and do go wrong. We don't need the AI Act to tell us that there really. And certainly when I approach risk and how to identify and mitigate some of those risks in an AI context, I like to start by thinking about, well, what are the potential harms that we're looking at? And that's where incident trackers can come in quite handy. Now, here I've kind of compiled a smorgasbord of incidents relating to AI and education in recent years, both on kind of this side and on the other side of the pond there. And I would hasten to add right from the start that, look, not all AI is created equal. So I'm not saying that all of these sorts of uses would necessarily fall within the specific definition of AI systems under the AI Act. But more I put them in there to kind of illustrate examples of what can go wrong when machines are essentially involved in education there. And we kind of got grading students, we'll remember that in the UK from a couple of years ago, to detecting AI created content, to emotional recognition software, to determining access to schools using facial recognition, for example there. there are plenty of different controversies, and there's no doubt much more to come down the line. But that kind of takes us to the AI Act, and these are the sorts of harms that legislators were really looking to try to address. And the AI Act itself is the first ever comprehensive legal framework worldwide on AI. And the aim of it is to foster trustworthy use of AI in Europe, certainly. And the truth is that most AI systems pose very little risk, but they have significant upsides to their use. But certain types of AI systems can create risks of potentially undesirable outcomes. And with that in mind, the primary focus of the Act is about preventing harm to the health, safety, and fundamental rights of individuals in the EU. And to make that happen, the Act creates a risk-based framework, and that establishes different obligations on individuals and organizations depending on their role in the value chain of an AI system, depending on the risks posed by that technology and or the specific risks depending on the context of use. So in today's talk, we're talking about use in an education setting. And the Act sets out harmonized rules for the development, the placing on the market, and the use of those sorts of systems in the EU. But rather than looking at it like the GDPR, which is very much focused on individual rights, the AI Act takes a different approach, and it looks at it from the perspective of product safety and the whole certification scheme around product safety. And essentially, if the AI product, we'll call it, meets relevant requirements, it will get a CE marking, and that will enable access to 27 markets across the EU. And the thing is about the AI Act, it doesn't replace, but it kind of overlaps in many ways with the GDPR. However, the AI Act scope is more expansive, and of course, it's not limited to uses of personal data. I'm not going to fearmonger by mentioning fines, but just be aware that they are GDPR sized. And like the GDPR, the territorial jurisdiction of the AI Act is expansive. And so it governs not just users of AI based in the EU, but also providers of the AI, providers outside the EU, where they kind of place them on the market in the EU, or where the output is used in the EU, or even where affected individuals are located in the EU. And that's why, I guess, similar to when we were talking about the GDPR many years ago, it seems now, there's talk of the Brussels effect. And essentially, that's where countries outside of the EU, or more likely organizations in those countries outside the EU, apply EU rules in order to standardize their products and services. And that's even more the case where there aren't many other prescriptive rules to follow. Now, why is education a particular focus of the AI Act? Now, I've put here an excerpt from the recitals from the AI Act. And as you can see, there are lots of benefits that are recognized at recital 56, so promoting high quality digital education, training, etc. But it also reflects risks. And really, it comes down to fundamental rights. The right to education is a fundamental right under European law. So that's in particular the European Charter of Fundamental Rights. And that boils down to the fact that essentially it affects an individual's prospects, their ability ultimately to earn a livelihood. And also there are other fundamental rights that come into play, such as the right to non-discrimination, given that there is a risk that is reflected throughout the AI Act of perpetuating historical bias. And that very often comes up in the context of the data that are used to train these systems. So the extent of that adverse effect caused by an AI system on those fundamental rights is of particular relevance when it comes to risk classifications of AI. Now, at this point, I'm also going to flag a slightly different consideration, and that is use for emotional recognition, because there is a lot of discussion about these sorts of systems and their use in education for a variety of different purposes. But as this recital here flags, there are scientific concerns about the performance of technology in this context, and also about the imbalance of power between teachers and students. And that means that there are particular concerns around the use of emotional recognition technology in an educational context. Now, I've got here the risk pyramid. Now, many of you will be familiar with the EU's approach to risk classification and the pyramid essentially there. And the greater the risk to health, safety, and fundamental rights, the closer that system is to the top of the pyramid. And this structure of a pyramid is also a deliberate choice by the EU, because the closer you get to the top, the fewer systems theoretically are likely to be caught. And the EU is at great pains to emphasize that most AI systems represent minimal or very limited risk. And that's kind of represented by the broader base of the pyramid there. But look, at the top, you've got unacceptable risk. And these are essentially a set of 8 uses of AI that are viewed as inherently harmful, because from the EU's perspective, they represent a clear threat to the safety, livelihood, and rights of people. And thus, as such, they take the view that these contravene EU values by violating fundamental rights, and on that basis are banned. And I've listed these on the left, and I want to highlight at this stage use of emotional recognition in education institutions there. Now, on the right, I've got the high-risk use cases, and I'll call out, third bullet point down, the education and vocational training. Now, these uses of AI have the potential to cause harm, but the EU takes the view that these are not in and of themselves inherently harmful, unlike the prohibited uses. And as such, they are allowed, but subject to important safeguards under the AI Act. Now, I've called out education in particular as a high risk. And there's a particular annex, it's Annex 3 to the AI Act, that contains a number of different use cases that are viewed as high risk. And that includes, as I've mentioned at 3, education and vocational training. And it's really important to look at the specific wording of this provision. So we're looking at education and vocational training, where the AI systems are intended to be used to, and I've highlighted key words here, determine access or admission or assign natural persons to educational and vocational training institutions at all levels, where these systems are used to evaluate learning outcomes, where these systems are used for the purpose of assessing the appropriate level of education, and where these systems are used for monitoring and detecting prohibited behavior of students during tests. So they are quite specific. So not every use of AI in the context of education will automatically be considered high risk. They need to be within these sorts of use cases here. And that's really important to keep in mind. Now, are there any exemptions? Yes, there are. And the exemptions when it comes to use of high risk systems is where there is no significant risk of harm. And that is in the context of, and they've illustrated this by 4 bullet points, so narrow procedural tasks, etc., etc. But the truth is that I suspect, whilst we have no guidance on what these means in practice at the moment, these exceptions are going to be very narrowly interpreted. And there is one key thing that I would also keep in mind, is that this exception isn't going to apply if the processing that you're doing involves profiling individuals. And profiling means assessing aspects of somebody's life, such as their performance, such as their behavior. And so very often where we're using AI in an educational setting, you are going to be doing profiling. So I suspect that this exemption is not going to be of much use in that context. Now, I mentioned a prohibited practice of emotional recognition. And so that is very much aimed at addressing the imbalance of power, particularly in a work, but in this context of this talk, an education context. And there are several cumulative conditions that have to be fulfilled that come out of this provision. You have to place the system on the market or use that system. It has to be used to infer emotions. And it has to be in the area of education and training institutions. addressing each of these elements. So there has to be inferences, and there's been some recent draft guidance that's been issued by the Commission on this that addresses these prohibitions. And they make clear there that these inferences have to be based on somebody's biometric data. And it distinguishes between these sorts of systems that merely detect readily apparent systems and systems that then make inferences based on those readily apparent expressions. So put simply observing a smile is not emotional recognition. Inferring that someone is happy from that smile is and will be potentially subject to this prohibition. But also keep in mind that it has to be in the context of these educational institutions. And so if you're providing an app for self-learning outside that educational institution, it seems so far that it might not be caught. So do keep that in mind when you're looking at whether or not the systems that you're using or providing are emotional recognition systems. And I mentioned that guidance, and it includes a number of really interesting examples that kind of illustrate the thinking behind that. You can look at this in more detail in your own time because you're going to have different areas of focus. But all I would say is that it's evident from these sorts of examples that not all uses of AI is going to be subject to prohibitions where it could potentially be used in an emotional recognition setting. And in particular, I want to call out two use cases on here in particular that are relevant to invigilation and proctoring, because I think these sorts of questions often come up. You'll see there that there's a reference to the use of eye tracking software when examining students there. So again, that's not prohibited if that's all you're doing. But if you're making inferences off the back of that around kind of, they say emotional arousal or anxiousness, then that might well be emotional detection. And they've got another example below there about inferring the interest and attention of students there. So do keep this in mind. But look, even if it's not prohibited, we still then need to consider whether or not it is a high risk activity and the sorts of obligations that are going to follow from that. Speaking of which, when it comes to those sorts of obligations, particularly in a high risk setting, it's going to depend on your role in the AI value chain. And I'm focusing on this slide here on the distinction between providers and deployers of these AI systems, but there are other actors when it comes to AI, the AI Act. Now, providers are on the left there. These are the developers of these systems, and they have the most onerous of these obligations. And I've listed these on the left there. So these go from the requirements around conformity assessments and CE markings to having risk management systems, data governance, particularly around data quality in relation to the sorts of data sets that are being used to train these systems, technical documentation that needs to be put in place, record keeping, developing kind of instructions for use. It goes on and on there. It's a pretty extensive list of obligations there, compared to, on the right-hand side, if you're deploying the system. Now, deployers are generally users of these types of systems that have been developed by providers. And as I've said, the obligations, so far as they are concerned, are rather more limited. And key obligations there include following instructions, making sure that there is human oversight, maintaining logs. There can be some transparency obligations around that as well. Now, these roles are not set in stone. And I think it's really important to keep in mind that someone can move from a deployer to a provider in certain circumstances. And you'll see I've put that arrow there. Those sorts of circumstances include if a deployer adds their name or trademark to a system that's been provided, if they substantially modify the system, or if they modify the purpose there. So do keep in mind that there is this risk of moving from a deployer to a provider in particular circumstances. Now, you'll see AI literacy, I'm going to come back to that later, is a requirement for both providers and deployers. And the extent to which there is education around these actors and even the staff, the individuals within those organizations that are using this tech, will impact on many of those different obligations there in different ways. And I mention prohibitions and AI literacy because the provisions that relate to that under the AI Act have already gone live, really. We're going to see enforcement provisions go live later this summer. And many of the high-risk provisions, as opposed to the prohibitions, are going to be going live next summer. So there is a little bit of time there to address that, but we need to be thinking about that already. Now, if you're not subject to the AI Act, or you're just wondering about what the UK is doing about that, we still need to be thinking about responsible and trustworthy AI. And here I've kind of summarized the government's approach in the UK, the pro-innovation approach in the policy paper to this framework. And it's underpinned by 5 values-focused and cross-sectoral principles. So safety, security and robustness, transparency and explainability, fairness, accountability and governance, contestability and redress. Now, these are all requirements that are reflected from the OECD. And the OECD, the UK and the US are both signatories to those principles. And the EU developed the AI Act by reference to those principles. So there is a lot of similarity and there is a lot of cross-pollination there as well. So do keep that in mind. Just because we're not necessarily subject to the AI Act, we still want to make sure that we're using trustworthy and responsible AI. And so these principles are nonetheless going to apply there. And with that in mind, don't forget that AI does not exist in a legal vacuum. Most countries around the world have laws around equality. In this country, we have the 2010 Equality Act. We have data protection and privacy laws around there as well. I flagged consumer and competition laws. But in the context of this talk, do also remember the sectoral requirements that apply. So Ofqual will have things to say about the use of AI, particularly, and it has done, around using AI, for example, to mark students' work. It's clear that using AI as a sole marker of students' work does not comply with its regulations. And that's because it doesn't meet requirements for a human-based judgment to be used in marking decisions. Same applies to remote invigilation there. So if it is the sole form of remote invigilation, it's unlikely to be compliant with Ofqual requirements there. So do keep in mind, not just the legal regimes that apply to your use of AI, but also the sectoral approaches that apply as well. Now, the final slide I wanted to kind of end up on is, what should you do next? And I think that these apply regardless as to whether or not you're subject to the AI Act. This is just good practice. The first of which relates to governance and accountability. Develop an efficient and effective strategy when it comes to governance. And where possible, you're going to want to leverage what you've got in place already in the framework of policies and processes. So you've probably thought about many of these sorts of issues in the context of your data protection compliance, for example. And having that framework is going to enable key decision makers in your organization to have oversight of your AI development and or your deployment of these sorts of systems through having those clear reporting and lines of accountability, having meaningful participation from relevant stakeholders across the business. And that needs to be cross-functional and cross-disciplinary for reasons I won't bore you with on this talk, but there is this concept of socio-technical risk, really, because the use of AI will change the risks depending on the particular use, and that all needs to feed into decisions that around the use of AI in the business. About empowering staff to interact with these systems, to do so responsibly by having these clear policies and processes, including on risk management. But that all has to be backed up through education, really understanding what they need to do around that. And mapping systems, that's a key part of your governance there. Because if you don't really know what you're using, you can't do much about it. And so that feeds into the second step, which is really, in terms of practice, having your inventory for AI systems and use cases. Catalog your use of those systems. Are you using AI systems? Are you developing it, or are you using it? If so, what for? Ask yourself basic questions like this. Once you've done that and you've got your catalog there, then you can start to classify those systems based on risk. Now, this might include, by reference to the risk levels under the AI Act, you might have prohibited systems, you might have high risk systems, you might have more limited risk systems where you still might have transparency requirements there. But you're also going to want to take into account your own risk appetite, or even the risk appetite of your customers there as well. The types of assurance mechanisms are going to follow based on your risk assessments there. And so these mechanisms might involve measuring, evaluating, and communicating the trustworthiness of the AI systems through techniques such as verification, evaluation, or even communications around that, and through audits there as well, and other types of assessments. Once you've done that, you're then able to apply relevant mitigations. So the exact nature of those activities are going to depend on those activities, so the context, but it's also going to depend on the risk posed. And it's a continuous process. It's not set and forget. It's going to need to be considered throughout the AI lifecycle. Training and awareness, education underlines all of this. And that's why I want to stress once again the importance in the AI Act, but also more generally of AI literacy. Upskilling staff that interact with these systems by promoting awareness and understanding through a formalized AI training program. And that's going to also help you get buy-in from the workforce around that, as well as from your customers to understand development and deployment obligations there. And that's probably a good note to end on a whistle-stop tour of AI and its use in education. And do reach out if you need a hand with any of this, including on training obligations there as well. And I think over to you now, Pat, because I think we've got some questions and discussion points which will hopefully bring some of this to life, because we could do an hour session on each of these slides in and of themselves. But look, hopefully that's...
Please no. I think that was absolutely perfect. Actually, just to say, because Ali and I did have a talk about this before the session started, and we were saying that if there was an appetite to do something more formal, such as a training course, etc., on this, obviously something a bit more involved, we'd be keen to do it. So we'd like to hear from people who think it's a good idea, they'd like to be involved or engaged, etc. So what I'm going to do is, I actually gave Ali some scenarios before we had a preparation session. So I gave him some scenarios. I think actually a couple of these have come up about the content side of things. So John, I know you put a comment in, and like I said, we prepared this beforehand. So this is a situation, I'm starting off with the easy, well, what I think is the easy one. So in terms of AI being used to write content for exams, so there's no actual interaction with the AI with students or pupils, etc., but you're using AI as a tool to help write items in an exam. Where does that fit in terms of the eAA Act?
Yeah, so we looked at before the high risk provisions. So the first question is the tool actually doing any of those determination or assessment type activities in and of itself? If it's generating content, I mean, it seems to me, if you're a deployer and you're using it to generate content, I would say arguably it's not being used within any of those specific use cases, to my mind. That's not to say that there isn't any risk with that. I think absolutely there's risk with using AI systems in that context. But to my mind, on a plain reading of the Annex 3 wording, which we looked at earlier, I would say that possibly not there as well. But hopefully, in any event, when it comes to managing that risk more generally, hopefully the fact that you've got a set curriculum that you're referring to there as well is going to help keep things on track. I'd like to think that there are going to be multiple stages, perhaps of human review there as well. Hopefully you've got policies and processes that need to be followed there when determining that. So I guess that comes down to, again, stressing those internal governance requirements. And I think one thing maybe to flag in this context is also, depending on how you're using, what tools you're using and how you're using them, I'd also think about confidentiality issues around the use of those systems. I mean, things when we're talking about use of generative AI, particularly publicly accessible forms of that, those sorts of solutions there, many of those sorts of confidentiality issues have been addressed, but it's definitely something that you want to keep in mind, because I think disclosing possible exam content might have wider ramifications there as well. So I think potentially not.
No, I think because it's one of the ones that I've had conversations with a number of people out over the last sort of 6 months ago, etc. And I think that realistically, people are using AI. It's like using a spell checker or, you know, a grammar checker or something like that. It's very ubiquitous, but it's not making the final decision. You've still got a human involved in the process. Now, I'm not saying that won't change in the future. And perhaps there might be more situations where you've got AI generating exams on the fly based on, you know, a particular job role or something like that. But I think for the moment, certainly it's very much based around the content. And like any exam, with people creating assessment content or exams, they are checking and validating that to make sure. So there is human oversight typically. I think that's the case.
I mean, it's again, I would just suggest going back to the exact wording of the Annex 3 provision there. And, you know, the system, if it's intended to be used to determine access or admission, I would argue perhaps that the system itself isn't being used. The content generated by that system is being used to determine access. So potentially. So I think it's potentially one step removed, but I think, look, you need to keep this under review. I'm just as new to this as everybody else on the call is. I have, you know, experience in dealing with these sorts of systems going back many years. But as far as the AI Act itself is concerned, you know, we're all kind of keeping a watching brief at what's happening. And as guidance comes out from the EU and we start to see thinking evolve on these issues, things may change. But I would certainly suggest that any form of risk mitigation is going to need to be applied in any event. So
I think there's another question here from Rakesh that was very similar about in content development. Again, I think if you're talking about learning content, again, it's not summative, it's not providing, all it's doing is providing learning for people. So I think that very much wouldn't be classed as high risk at all, because you're just using the content or AI to create material which is being used as a study guide rather than you're actually assessing people. I think, again, there was another question here about formative as opposed to summative assessment. I think if you're using AI in a formative context, i.e. there's no end result, no one's going to get a job, lose a job or whatever, but it's using to provide feedback for student, is that something that, again, you would think would fall outside the Act?
I think, again, we need to think of it in the particular context of use. So I think that, yeah, it comes back to what the wording is of that Annex 3 provision there, and kind of working out whether or not that is or isn't the case, really. So I think, you know, it's something that we can have a greater discussion about, but I'd be reluctant to say at this stage that it's very much yes it is or no it isn't. I think these things are very much more nuanced than that, and the reality is that you have to take a risk-based approach with this.
I must admit, I did like that on your introduction when you were saying about the approach to this is much more like as a framework. It was, you know, I really appreciate that, because I think they're not doing this to try and catch people out and make it difficult for them and be obstructive. They're doing this to make sure individuals are protected. So I think provided you as an organization, an individual, have that attitude to things, is someone going to be disadvantaged, is it going to be difficult, then I think that's the key. And it's interesting, and I know you drew that out specifically because we spoke about this, where you're talking about eye movements in an exam, because that's one of the criteria that I know that online proctoring companies, you know, if someone's, you know, moving their head or looking up, etc., to read notes or something like that, would be deemed acceptable, because all you're doing is saying, okay, there's something going on here. However,
yeah, exactly. I wouldn't say acceptable. It's not prohibited if you're not making inferences off the back of that. So if you are using eye tracking software in order to make inferences about someone's emotional state. So are they particularly anxious, for example, because they're going to be rumbled, because we think they're cheating, then that would clearly be a prohibited practice there. But actually, because you're using that to infer their emotion, make inferences about their emotional state. But I would very much distinguish that between the high risk use cases, which again, when we looked at that Annex 3 provision there, systems used for monitoring and detecting prohibited behavior of students during tests. It's not prohibited, but it is high risk. So we need to make sure that we are compliant with our high risk obligations there, depending on whether we're a provider of those sorts of systems or whether we're a deployer of those systems. So sorry, it's just a slight nuance there.
No, because I must admit, and I must apologize, I can't remember who it was, but I remember attending a presentation at an event and someone was saying that they were using people's emotional state to help judge the questions and whether they were difficult or not. So not just based about psychometrics about the exam results, but also how the candidates viewed the exam. They also went, oh my goodness, I'm worried about this. Then that might provide some inference. However, that might not be acceptable because obviously back to the point that you just made, because you're using that information. So I think back to the point, it's very nuanced. It depends on your particular use case. And if you feel that you can mitigate the risk and justify it. I mean, for example, I still know this happens in the UK with exam boards. If a student's writing an exam and they're writing something that's a bit of a concern because they sound suicidal or something like that, that will actually get flagged up by the exam board with the school and something will be followed up. So there are situations where perhaps someone's emotional state might be viewed as being acceptable to understand there's an issue, because actually there might be a knock-on effect to that person's health and well-being, etc. So like you said, but I'm not saying that's acceptable, but it shows there are always exceptions.
No, and you're absolutely right there, Pat. There are other exceptions. Look, I mean, there's only so much I can do in a half-hour overview, but there are even within what we've discussed particular nuances there. So absolutely, I mean, the classic example that they cite is you're inferring emotions, but you're doing that for safety. So, for example, a pilot's state of emotional state, for example, that that's going to affect the safety of the pilot and everybody else around that. And so in that context there, and there are also other issues around pain and other types of physical reactions as well there. So look, I think that these are very nuanced discussions. And so I'm not saying yes or no. We have to think carefully, but the emphasis, certainly from an EU perspective, has been about, look, accountability means, and certainly we've learned this from a GDPR perspective, it's not just about being compliant, it's about being able to demonstrate that you're compliant. And that's where this whole concept of accountability comes in. So it's about being able to demonstrate that you have thought through all of these issues, reasoned through them, identified the risks, and mitigated any of those risks through this. And that's why it always comes back to kind of governance and accountability around that.
Okay, I'm going to mention this one now because we will get to the other questions. I apologize, I'm not doing the order, but I'm trying to do them in sort of the biggest, chunkiest topic. So the one that probably is closest to my heart is this about AI marking of essays. So that's using AI to grade and mark student essays. I'm always passionate about this because I think this has probably the biggest opportunity to radically change the assessment system and the way things are working at the moment. However, it's potentially the most contagious. Now, I would argue that AI is equally inaccurate as humans, but we're accepting the fact that humans are all right, that they make mistakes and they don't get things right. But I think technology is being held to a higher standard. So it's a summative assessment, whether it's for pre-university or it's in whatever the situation is. Where would that sit in terms of high risk or not? I guess for you, Ali.
Well, I think again, you need to go through all of the provisions. Firstly, it depends on what you're marking and how you're marking it, because the first question is as I said earlier, actually at the beginning of the slide, not all AI is created equal, essentially, right? So is the AI that you are using to mark, is that an AI system within the definition of the AI Act? And I say this because we've had some recent guidance on what AI systems actually look like under the Act. And look, if these are more simple systems that are being used, kind of rule-based systems that are being used to automatically execute operations, then it may well be that the marking or scoring system that you have is not an AI system and doesn't fall within the Act. So that's the first question that I would ask right from the outset there. But look, if we assume that we are kind of within the kind of technical, within the territorial and material scope of the AI Act, then we know that where we're talking about evaluating learning outcomes or assessing levels of education there, those probably are going to fall within the wording of the Annex 3 definition of high-risk systems there. So I think that's probably yes. And the sorts of requirements that are going to flow from that are going to depend on whether you are a provider or whether you're a deployer. And I think we also need to keep in mind those sectoral specific requirements, for example, Ofqual or whoever else that we might need to keep in mind. So there is it's a complicated patchwork, I think, of considerations there. And I haven't even mentioned the GDPR in all of this. So these are where you're making automated decisions using personal data. There are a whole separate series of considerations that you're going to need to consider in that context as well. And very, very often, automated decision making ties in with use of AI systems there as well. So there is a lot to consider.
I suppose as well that the thing about the essay marking, for want of a better word, it could be anything, but let's use the word essay because it makes it easier. What you've got there is you've got potentially something that's generative AI being used to score or mark essays. You could have a bespoke model where it's an English essay and it's a particular cohort, even though there might be hundreds of thousands of students in that cohort, where you're training an AI model specifically around English essays for that, whatever. One might be deemed acceptable because one might not because it's generative, etc. So I think, again, I know it's very, very difficult. You've got to really understand it, look into the depth and actually do the analysis and decide, is this appropriate for us? Is this high risk, etc. And then the key is mitigating that risk about, have you done research? Have you done pilots? I'm guessing that's the sort of evidence that if you can show that it's acceptable, is that the sort of thing that might be included in the documentation, your governance process?
Acceptable from a impacted individual
perspective, yes.
Yeah, I mean, look, again, wearing a data protection hat, we have this concept of data protection impact assessments, and you need to do that in certain situations. Let's assume you meet the threshold in order to be able to do that. Now, part of that assessment process is consulting with various stakeholders, and I would suggest that one of the key stakeholders, I think Stephen has put a comment in the chat there. Sorry, I'm not following the chat as closely as struggle to multitask, but I think that there is that kind of consulting with relevant stakeholders. So in the context of children, the children themselves, maybe the parents, anybody affected by this, you definitely want to kind of have a think about whether or not you're going to involve them in that process and get their feedback there. So I think that's very sensible.
Yeah, I think just one comment at the end here. So I apologize, I'm not doing it in order again. It's mentioned about the fact that in a school context, someone said that if an AI was used to mark a child's exam, then they would want it remarked. So having both my parents being teachers and being at 2 o'clock in the morning marking exam papers because it's a deadline, I think I'd personally rather have AI mark my essays because I think it would probably be more accurate and less prone to vagaries. But
I think again, that's really, oh, sorry.
Go on, please go on.
Well, I was going to say, but that's a really important point when it comes to use of AI. AI has the potential to provide for a much more meritocratic system. You know, we're tired. We might have innate prejudice somewhere in our mind. We might have kind of over prejudice for some people, you know, and the reality is that actually, if we get it right, there is a promise of being able to have a much fairer system to everybody involved, that teachers are able to kind of dedicate their time to actually ways in which they can make a meaningful difference and add value to that situation, that students can benefit. Everybody has the potential to benefit from this. And that's why it's really important when it comes to, I think, particularly when we're looking at the way in which providers develop these sorts of technologies, that they do keep in mind kind of the risk management systems, the quality management systems, all of these sorts of obligations under the AI Act, because these are going to be really important to be able to make sure that we've identified and addressed many of these sorts of risks. And if we do that well, then there is a lot to gain for everybody, really, I think, through the process.
Absolutely. I think someone's just mentioned, actually, and Stephen again, and I hear this expression all the time about explainable AI, and I don't really know what it means, to be quite frank, because it's like you explain how someone's brain works to me. It's a bit like, not really. It's a word that I hear more and more. Can you explain explainable AI to me?
Yeah, no, absolutely. Well, no, it's good Stephen's mentioned that. Yeah, look, explainable AI or XAI, as they like to refer to it, is basically really focused on understanding how a decision was reached. And there are lots of different techniques that aim to provide more transparency around decisions and to kind of make those decisions understandable. So that goes to interpretability of decisions. And, you know, we talk about this a lot in the context of black box decision making. So where we don't really understand what the model is doing in the background, especially when it comes to deep learning systems. So this is where you have artificial neural networks that function similarly to the brain, but through the weights and biases in the parameters, they're making these decisions there. And so, look, there are difficulties really in understanding how these systems work. But I think that what we are learning is that increasingly there are technical means of being able to better understand what is going on in those black boxes there. And that's really important because, look, it's one thing to actually be able to explain at a very scientific basis what's going on within, as I mentioned, those neural networks there. But there is a separate element. And really that comes down to, if we don't understand what's going on when it comes to making these decisions, then how on earth are we going to explain how we've reached these decisions to those individuals who are impacted there? And so that's where we have this link between explainability and transparency. So when we're telling users, or impacted individuals, I should say, actually, about what factors were relevant to a particular decision about them, well, it's going to be difficult if we don't actually understand what's going on under the hood, so to speak, there as well. It's going to be difficult. You've seen there are references to human oversight, but very often when we talk about, as I've mentioned before, there's a whole data protection regime that sits in parallel with the AI Act. That where we talk about automated decision making, one of the key safeguards there is basically having a human in the loop. Now, having a human in the loop in and of itself isn't going to mean much if essentially they're just rubber stamping decisions without actually applying any thought to what's going on there. And certainly if they don't understand the factors that were relevant in order to reach a particular decision, then I would suggest that there's room to consider, at least, did they really understand? And if they don't understand, then is that decision actually meaningful in that context? And explainability comes up not just in the context of the actual reasoning of the models from that perspective, but it also comes up, I mean, we've been thinking about it for many years from a data protection perspective, because many of you will be familiar with the right of access under the GDPR, so subject access requests. And essentially, it's not just the right to have a copy of your personal data, but also it's the right to have meaningful logic about the decision making there. And so we've been talking about it for many years in the context of credit scoring in particular, and those decisions have gone up to the CJEU, the European Court, Europe's highest court, around that. And in fact, we just had a decision the other day, actually, on Dun and Bradstreet, around the explanations that were being provided around that. Because look, I think somebody else at some point made a comment about, well, the more detailed the scientific explanation, is that going to meet our obligations? And very often when we talk about use of AI, we talk about trade-offs that are being made. In a data protection context, we talk about, well, the more data that are being used by these systems, we know the better they perform, right? But how does that work with our data minimization obligations under the GDPR? And similarly, there is a trade-off when we talk about explainability of these systems and transparency, because look, having much more detailed understanding about how these systems are working might be great for the scientists, but actually it's going to be meaningless to the individuals that are impacted by these decisions. So even if you wanted to actually kind of take the AI model and provide it to a user and say, well, actually, we've complied with our requirements here, because separately under the AI Act, there is this right to an explanation. It kind of ties in some ways with the right of access, the meaningful logic of the decision making under the GDPR. But actually providing most people affected by AI with a copy of the model itself is going to be useless. Yeah, you might be able to argue, well, they're going to be able to work out exactly what went on, but it's going to be not very helpful. And that's why, actually, interestingly, when it comes to credit scoring, there's a lot of talk about counterfactual interpretations. And in that Dun and Bradstreet's decision, there's, to my mind, an emphasis, and it's something as a firm we've been talking about, because we do a lot of work in the workplace context, which is another high-risk use case along with education. And we've been really talking a lot about local explainability. So being able to explain in relation to that particular individual, what were the factors that led to a particular decision being reached, and how would the decision be different if some of those factors changed there. So all that to say, it's going to depend on who you are, and also about making sure that whatever explanation you're providing is proportionate and effective depending on that audience. I think that's quite a long-winded way of saying that.
That was a yes then. So I'm just going to talk about something else. We've only got 6-7 minutes left, but actually I think Tim and John both mentioned something about this. So obviously, technically we're not part of the EU, but I know there is still working relationships between the UK, the British Standards Institute, and the International Standards Organization. I myself am involved in a project. I know the BSI have 50+ AI projects going on at the moment, etc. I was at an event, an all-party parliamentary group last week, and it was talking about the assessment curriculum. So learning and assessment in the curriculum, and they mentioned AI as well. Is there a direction, and I know you alluded to it earlier on with the OECD, etc. Is there a direction the UK is going? Will we have an equivalent? Will we just adopt the eAA Act? How do you feel, or what do you think about that's likely to be? From a UK perspective, specifically from a legislation point of view?
Yeah, well, look, I don't want to get too much into politics, but very much we've taken in this country a pro-innovation approach, and that's set out in the government's paper on this issue. And in many ways, we look across the Atlantic, and the idea there is, look, let's tear up the rule book, let's work out how we're using these sorts of systems, and then as we start to use them, we can work out those harms and address those harms. It's a very different perspective to that of the EU, which likes to set the rules in advance and then kind of work out how these sorts of systems can be used. And look, obviously, we've got our closest neighbours and markets, one eye across to the States and one eye across to Europe. And so we're in kind of quite a difficult situation in the sense that, we don't have a seat at the table anymore in Europe. We used to have a big voice in Europe, and we used to be listened to in that sense. So we used to have a say in what was going on there. So now we're in a situation where actually, if we want access to that market, providers of these systems are going to have to comply with those rules. There's no two ways about it. But on the other hand, we want to make sure that we are very much innovating and growing our economy. But we don't exist in isolation. The UK is not the only market for a lot of edtech solutions there. We have an eye to the world. And that's why I was talking about this Brussels effect, which essentially, is it going to be the case that the AI Act is going to kind of become that default benchmark? Or is it going to be the case that actually a lot of these systems are going to be developed outside of the EU and only later they're going to be tweaked for use in the EU? Who knows? From a UK perspective, we're very much focused on relying on particular regulators in particular sectors to make those key decisions, Pat. And I referenced to Ofqual, but there are various other even outside of an education context, different regulators are going to have different things to say about this, and there are going to be overlaps between different regulators. So if you're using AI in an education context and you're using personal data, you're going to be subject to the ICO's jurisdiction there as well. The UK government are very much focused on frontier models, but look, let's see. There's a lot to play for, and there's a lot to consider in all of this as well. But I think that sticking to the core principles, you're not going to go far wrong. And certainly from an ICO perspective, if you're in compliance with what data protection law wants, then you're going to have done a lot of the lifting. Data protection law deals with accuracy, it deals with fairness, it deals with security, it deals with transparency. So many of these concepts that we see from an EU perspective, we're already doing when it comes to data protection. Yes, there are nuances, there are some differences, but it's very much a way of kind of getting 80% there, if you like, quite quickly. And the only other thing I would mention there in the context, you mentioned the BSI. So from a EU perspective, there are going to be lots of standards that also complement the AI Act. And Sensenelec, which is the EU standards agency there, if you like, are working and have one eye on international standards, so ISO or kind of BSI in this country, in order to develop those sorts of standards and frameworks there as well. So they are alive to that. So yeah, keep an eye.
I guess the other thing as well, just as a final note, the challenge is at the moment, there's no case law, is it? It's not like there's hundreds of cases that you can compare and precedent have been set. It's because it's all new. And I guess that's why, hence your analogies with GDPR, because that's the closest you have.
Yeah, exactly. It's all new. And I don't think I'm being unfair in saying that the EU are making it up as they go along. We've got the AI Act, but the AI Act itself is, there are a lot of gaps which the EU recognises need to be filled, and that's where kind of these standards, the guidance that comes through is going to be really crucial in filling some of those gaps. So we haven't even got to consider case law. We're way off any of that at the moment. We're still very much, many of the provisions under the AI Act haven't even gone live yet. As you've seen, we're only at the beginning of that journey, but certainly rules around prohibited practices and rules around AI literacy, those are already in force. So, we need to be thinking about those already if we're subject to the AI Act.
Fantastic. Well, we've reached time now. I know we could go on. What I would say to everybody is I virtually give Ali a round of applause. I thought it was fantastic. I've got a much better understanding now of the EU Act and how it applies in our context. I think I had a good idea, but actually it's clarified some of the questions that I have. I apologize we didn't get a chance to answer everyone's questions. We will be going through them and giving, writing the responses, etc. for those. I'm sure we'll be using AI, so I do apologize on that one, to be able to do that. And Ali kindly said, if anyone's got any specific questions, then please feel free to reach out to him or reach out to us. And finally, if you have any ideas about other topics you'd like to do, or if you'd like to see Ali again and delve into essay marking on its own, because we did have a number of questions on that one, or online proctoring or something else, then please let us know. If you email operations@eassessment.com, they'll be able to broker all that. And finally, if you do want to get involved in a special interest group, please let us know as well. So once again, thank you very much, Ali.
Perfect. Thanks for having me on, Pat.
Thanks a lot. Thanks a lot, everybody, and we'll catch up again soon. Bye-bye.